Good morning, everyone. Good morning, everyone. Good morning to everyone here in Assembly Judiciary here in Carson City, as well as those in, I don't see anyone right now in Las Vegas, and of course, anyone watching online, either through Nellis or through the legislative YouTube channel. And with that, Committee Secretary, please take the roll.
Assembly members Cole, Dahlia, Gonzalez, Gray, Hanson, Hardy, LaRue Hatch, Marzola, Moore, Nadeem, Ortlicker, Roth, Urick, Chair Miller.
Here, please mark Assembly Member Moore absent excused and Assembly Member Ortlicker present when he arrives. And with that, just a few reminders, asking everyone to please turn down the volume on their electronics before we begin. Also, we will have 3 bills today in public comment, asking presenters to keep their presentations to 15 minutes, and anyone testifying on bills or making public comment to keep their comments to 2 minutes. Of course, everyone speaking, we ask that you state your name first and spell it the first time so that we have it correct for the record. I will provide the phone number for those that will be participating over the phone, and the number is 888-475-4499, and the meeting ID is, 831-383-40211. And with that, we will go ahead and begin. Also, members, as you'll see, there are some amendments for both bills, for 303 and I believe this is 359, that you have paper copies. These are last-minute submissions. We all know what happens with last-minute submissions, so please take some moments to review those amendments as they will be part of the bill presentations. With that, I do plan on taking the bills in order, so we will begin with Senate Bill 303. So I'm opening the hearing on Senate Bill 303, which revises provisions relating to civil liability to persons using certain premises for recreational activity under certain circumstances. And with that, once you all get settled, please introduce yourselves and then proceed when you are ready.
Good morning, Chair Miller, Vice Chair Marzola, and all the members of the hardest working committee in Carson City. My name is Justin Watkins on behalf of Nevada Justice Association, and I'm pleased to present SB 303. We submitted an amendment via email, and you should have copies in front of you. This amendment language is actually the complete bill, so I would term it as a rewrite of the bill in total. So the blue sections are new, the black sections are existing law, and the red are obviously deletions. I'm going to start off by giving a little bit of a background as to why this bill is being presented today, and then turn the presentation over to Ben Cloward and his team, along with one of their clients, Vicky Ozuna, to describe what's happening in a case that's actually in court right now, to further illustrate the need to clarify the legislature's intent for recreational immunity. And then I'll come back, walk you through specific language in the bill, and answer any questions that you may have. So I'll start off by indicating that the purpose of the recreational immunity statute, which was enacted in Nevada in 1963, was originally to incentivize rural private landowners to make available their open land and water to the public for free without having to worry about liability for any injuries or damages caused by people who were recreating on that land. When looking at the intent, Nevada courts specifically stated, quote, recreational use statutes generally apply to premises in rural, semi-rural, or non-residential areas and to injuries incurred by an activity enumerated in the statute that can be pursued in the true outdoors. In response to that interpretation, the legislature in 1995 expanded recreational immunity to any premises. And for nearly 30 years after the legislature expanded recreational immunity, there was not a lot of misinterpretation or disagreement about who this statute applied to. It was, I've been practicing for 20 years now. Never did I see a private for-profit company working on land that would otherwise be recreational claim this recreational immunity. It was cities, it was states, it was rural landowners that usually used this argument of recreational immunity, and it was applied. And what happened and why we are here today is late last year, the Supreme Court, in a case called Abbott versus City of Henderson, ruled that a mother who was walking with her child and supervising her child on a playground and fell due to a hazardous condition on the ground could not pursue her claim against the City of Henderson because the city was protected under recreational immunity. And just so we're clear, nothing in this bill would change that ruling. However, the Supreme Court in dicta, which is basically language or comments that have nothing to do with the ruling itself, left open the possibility of an argument for the first time by these private for-profit enterprises that they should be protected from liability based on the immunity that the City of Henderson was afforded in that case. Before I walk through the language, I will turn this hearing over to Ben Cloward, and then attorneys Riley Clayton will be up here as well, along with Vicky Ozuna. And as you can see, in order apparently to be an attorney in the state of Nevada, you must not have any hair. So hopefully you don't confuse any of us. So with that, I'll turn my hearing over to Mr. Cloward.
Good morning, Chair Miller, Vice Chair Marzola, and members of the Assembly Judiciary. My name is Ben Cloward, last name spelled C-L-O-W-A-R-D, of Cloward Trial Lawyers. I represent the Ozuna family, and in particular, I am here today with Vicky Ozuna, the widow of Anthony Ozuna, who lost his life in September of 2020 as a result of some out-of-state companies cutting corners during the construction process. I will allow Ms. Ozuna to share the details in a moment of how her husband lost his life. But our firm was hired to assist her in the litigation process to hold those companies accountable for very clear shortcuts they took, which my partner Riley Clayton will also address. My role today here is to simply share the brief procedural history which led to the current issue. In August of 22, a lawsuit was filed against 4 large national companies, 3 of them being incorporated in Delaware and 1 being incorporated in New York. Over the next 18 months, several amendments to the complaint and amended answers were filed. In all, there were approximately 9 amended answers filed by the defendants to the complaint. In none of those 9 answers was the recreational use statute ever asserted as a defense. And in fact, prior to this case, in my 17 years of litigation on behalf of plaintiffs, as well as representing defendants, has any road construction company or the like asserted this statute as a defense. However, as a result of the Abbott decision, all of the out-of-state companies in Ms. Ozuna's case rushed to the courthouse and asked the judge to give them permission to amend their answers to assert the recreational use statute as an affirmative defense to deny the Ozuna family recovery for the death of their beloved husband, brother, and father. We believe that this is not in harmony with the legislative intent and certainly is a major departure from the way this statute has been read and understood by both plaintiffs and defendants for the last 30-plus years, as evidenced by the fact that this defense was not included in any of the first 9 answers or amended answers until after the Abbott decision. So with that brief procedural background, I will now turn the time over to Ms. Ozuna to explain what happened to her husband, We sincerely appreciate the hard work and service that each of you offers to the citizens of Nevada. Thank you for allowing me to be heard on this important issue.
Good morning, Assembly members. My name is Vicki Ozuna. I am a resident of Clark County, and I am here today on behalf of myself and my family to respectfully urge you to support for greater clarity and fairness in Nevada's recreational use statute. I dedicated 28 years of my life to public service with the City of Las Vegas, working mostly in the field of code enforcement. In 1998, I became a code enforcement officer, and then when I retired in 2022, I was proud to be serving as code enforcement manager. Throughout my career, I worked in several departments with a primary focus on ensuring that enforcement of city ordinances designed to protect public safety and maintain community standards were held. In my professional experience, I've seen firsthand how crucial proper protocol is in keeping people safe and how quickly things can go wrong when these protocols are ignored or bypassed. Today, however, I speak not only as a former public servant, but as a wife and mother whose life has been forever changed by a devastating and preventable tragedy. My husband's name was Anthony Ozuna. He was a lifelong Nevadan. He was devoted and a loving father to all 5 of our children, 3 of whom he was proud to call his biological own, though he cherished each and every one of them with his whole heart. He was the rock of our family. He was kind, funny, dependable, and so full of life. We shared a beautiful life together filled with laughter, love, everyday moments that became treasured memories. Whether we were running errands, relaxing at home, or taking family vacations, we were at our best when we were together. He made everything feel complete. Anthony worked for many years as a journeyman sheet metal worker, a career he took great pride in. He retired in 2017, and we look forward to a long and well-deserved chapter of rest, travel, and enjoying the fruits of his labor. Sadly, that time was far too short. After retirement, Anthony focused even more on his health. He had diabetes, and one of the most effective ways he managed his condition was through cycling. Riding his bike wasn't just a hobby, it was a critical part of his health routine. It helped him manage his blood sugar and keep his body strong. What began as exercise quickly became something he loved. For nearly 3 years, he rode almost every day with his brother Andrew and his sister Cindy, usually early in the morning. Anthony took every safety precaution seriously, from wearing a helmet, reflective clothing, to using flashing lights and proper cycling shoes and following all traffic laws. He studied road safety and took it to heart. He was not only a passionate cyclist, but a responsible and experienced one. That morning, I received a phone call from his sister Cindy. That's why what happened on the morning of September 1st, 2020 was so unthinkable. That morning, I received a phone call from his sister Cindy. She didn't give any details, just said there'd been an accident and that I needed to get to UMC Trauma right away. I was just stepping out of the house to head to work. I called out to my daughter and asked her to come with me. The drive to the hospital was something I barely remember. I just kept thinking, let him be okay. When I saw him for the first time, I was completely unprepared. The strong, vibrant man I had shared my life with was lying in a hospital bed, motionless, and couldn't speak. They advised me he was paralyzed from the neck down. It was the most terrifying moment of my life. I could barely process what I was seeing. It didn't feel real, but it was. Over the next 11 days, our family endured the kind of pain that no one should ever have to go through. We learned that every bone in Anthony's neck had been broken. He underwent an emergency surgery that lasted 9 hours, a surgery that meant to help him retain his ability to breathe on his own. After the surgery, he was put on a ventilator. And then, due to COVID-19 protocols, we were told we could no longer stay by his side. Anthony, the most compassionate, loyal, and loving man I have ever known, lay alone in that hospital for days without the comfort of his family, without knowing we were there praying for him and loving him. The next time we were allowed into the hospital, he had suffered a stroke. The hospital gave my daughter and me just 30 minutes with him. The doctors told us he was likely half brain dead and that they also suspected he was now blind. That was the moment I knew my Anthony, the man who loved me, loved life, his family, and gave everything his all was gone. September 9th, after much grief and painful reflection, our family made the decision to remove him from life support. On September 11th, the day before his 63rd birthday, Anthony was removed from life support and passed away. What makes this all more tragic is the fact that it didn't have to happen. We later learned that the construction crews working in the area had begun placing cones and barricades before they were authorized to do so under the approved traffic control plan. At that hour, the sun was just rising over the mountains. The glare on that stretch of road was blinding. Anthony told his medical team that he didn't see the cones. He struck one and crashed. Had the construction crews waited, as they were required to do, this accident likely never would have happened. To make matters worse, I have since learned that the construction companies involved are trying to avoid responsibility by citing the Abbott versus City of Henderson case. Anthony was doing everything right, using proper safety equipment, following the rules of the road. It was the construction crews who broke protocol. Their negligence directly caused his death, and now they're trying to hide behind a technicality. My husband's life mattered. He was a husband, a father, a grandfather, and a man who lived with dignity, responsibility, and love. He did everything right. He deserved better. We all deserve better. Please help ensure that no lives are devalued by legal technicalities. Thank you for your time and listening to our story.
Good morning, Chair Miller, Vice Chair Marzola, and members of the committee. My name's Riley Clayton, and I'd like to provide a little bit of factual background to give a little more context and insight into the story, and why clarifying NRS 41.510 is necessary. In the Ozuna case, certain contractors needed to upgrade their underground cable network in the city of Las Vegas. To perform this work, the contractors needed a construction permit and an approved traffic control plan. The work would be conducted on Elkhorn Road, which is a major street in Las Vegas, 2 lanes going in each direction with bike lanes on each side of the travel lanes. The contractor submitted a traffic control plan to the city. The plan even included closing off the bike lane for this particular project. The proposed traffic plan specifically indicated the time for setup and takedown of the cones and barricades. It says hours of setup, 7 a.m. to 5 p.m. when school is out, and then between bell times when school is in session. The same traffic control plan also said this plan is void if there are no flaggers. In this case, the city has testified that setting up cones before 7 a.m. would violate the traffic control plan, that failing to have flaggers out on this site would void the traffic control plan, and that they expected these contractors to strictly comply with the traffic control plan. Vicki testified correctly that her husband was out on the road at about 6:30 in the morning. The construction crew had started setting up these cones, these signs, at 4:30 in the morning. I asked this contractor in his deposition why he set up these cones in violation of the traffic control plan. He testified, "This is how I was taught by my employer, road safe. And that I needed to set these up as early as possible because I had some 12 other setups that needed to be done that morning. The motive was clear. This was done for profit, not for safety. Had these contractors complied with the traffic control plan as they told the city of Las Vegas that they were going to do, this horrific, tragic accident would not have occurred. Now these contractors are seeking immunity protection under NRS 41.510.
And so with that, I mean, first I'd like to say we are deeply sorry for what you've experienced. Deeply sorry, and thank you so much for coming today and sharing with us. Thank you. With that, as we before we move on to questions, is there anything else you would like to address that's in the bill or the proposed amendments?
Thank you, Chair Miller, Justin Watkins, for the record. If the chair would like a walk through technically what the proposed conceptual amendment does.
Yes, please.
So the intent of this proposed conceptual amendment is to address three things. To whom does recreational immunity apply? What kind of land or where does it apply? And for what activities? So if you look to section 1 of the proposed conceptual amendment, this is discussing two of those items, who and where. The who are two different categories of owners. The first is the state of Nevada or any political subdivision thereof. So that's cities, counties, state, that's RTC. The language is throughout our statutes. The second is private owners in rural areas that make their land available to the public for free. So we have a very limited category of the who. The where is, in regards to the state of Nevada, those lands that are intended for recreational use. And you see in section 2 of the bill, how do we determine what lands are intended for recreational use, or if they're included in the city, county, or state's recreational plan, designated or permitted for such, or a part of a trail system that is included or intended for in the recreational plan. So, state of Nevada, any political subdivision on their recreational land, and private rural landowners who provide their open land for free to the public. That is the who, and that is the where. When you look into section 3, that is defining with specificity what we mean by those private rural landowners, and making clear that that does not apply to private urban or semi-urban landowners in residential areas. Section 4 of the bill discusses what that immunity means. This is existing language. It means they owe no duty to keep the premises safe. It means that they do not extend any assurances that the premises is safe, and that there is no duty of care for or ground of liability for injury to the person, with the exceptions that, again, are currently in statute. Those exceptions include willful or malicious failure to guard or warn against, for injuries suffered if the landowner is paid, or injuries caused by the person for whom the permission is granted to enter the land. We have now added 2 additional sections to these exceptions to liability. The first is, we are now in section 6D. We want to ensure that the immunity that's being provided to the state of Nevada is limited to the state of Nevada, and that nobody who occupies, uses the lands that would otherwise and are provided for immunity for the state of Nevada extend to anybody but the state of Nevada. So, if the state of Nevada allows somebody onto the land, they're using the land, they do not get recreational immunity. It does not, there is a sort of a concept in the law, the protections do not run with the land. They are individualistic. So you have to satisfy all three grounds. You have to be the type of person that has the immunity, it has to be the kind of land that is protected, and the activity must be the type that is contemplated. The existing language in regards to recreational activity is in statute now. You see all the listings. That's a non-limiting list. And then you'll see that we've added some clarifications as to recreational immunity, that does not include utilitarian activities performed for work or transportation, meaning a person on a bike may be recreating, but is not necessarily recreating just because they're on a bike. A person walking may be recreating, but is not necessarily recreating, depending on the purpose for which they are walking. And then you will lastly see in the final section 6 there that as part of working with stakeholders, we are attempting to address a concern from state entities that despite having immunity, they are sometimes kept in cases where the issue of immunity is not resolved at the district court level, and they are stuck and have no appeal rights until a case is done, which can be quite expensive. So in this instance, when the court either applies or refuses to apply immunity, either party can take the case directly to the Supreme Court to have the Supreme Court decide that issue right then and there, so that the parties and the judiciary aren't wasting resources in moving a case forward that otherwise should not exist. And with that, I submit myself to questions.
Thank you so much. I believe we'll begin with a question from Assembly Member Cole.
Thank you for the presentation. This is very interesting, and I can't wait to do it more of a deep dive on the amendment. But my question is on 6D, where we're talking about the protections provided in Section 2 are limited to the state of Nevada and political subdivisions and shall not extend to any other person or entity leasing, occupying, or using said premises. So I used to, in my younger days, run a lot of half marathons. And so my question is, what happens if you have a race group that is running or even a cycling event? Are those guys protected? Thank you.
Thank you, Assembly Member, for the question. Justin Watkins for the record. Wonderful question. And it does a good job of showing what the intent of this is. In that situation, let's assume that a bike race or a marathon is on state, city, or county property, and that the race organizers were permitted by that entity. The state or the city or the county would be immune from liability. The race organizers would not.
Sure, go ahead.
And are they immune now under any law or?
Thank you, Justin Watkins, for the record. My interpretation is no. For the last 30 years, my interpretation has been no, that there is no immunity for a private for-profit enterprise that engages in commerce of recreation. However, the dicta of Abbott has empowered some litigants to make the argument.
Okay, thank you. Our next question will be from Assemblymember Urick.
Thank you, Chair, and thank you for the presentation this morning, and our hearts go out to you, ma'am, for your loss. And I appreciate what this bill is attempting to do is to provide additional clarity that the Supreme Court kind of left open. And I also want to tell you personally, as I've been lobbied by the folks on this, I appreciate the effort that's gone into provide clear language that will satisfy the intent that I think you've clearly established here through this presentation of the conceptual amendment. But to make sure that the record is abundantly clear, I would like to have you affirmatively or negatively answer this specific question, and that is, other than the rural piece that already has existed and has been interpreted for a long time with respect to this kind of new language clarifying immunity to the state and its political subdivisions, that very specifically what you mean by that is immunity would be granted to those entities, again, on recreational property is defined, for recreational activity is defined, to the state of Nevada and all of its political subdivisions. That would include the counties of this state, the municipal agencies or entities of this state, all of the cities, and other political subdivisions, as you have articulated, are used throughout the statute. And it does not pass through to anybody else, but it would specifically provide the immunity that this statute contemplates for those entities.
Thank you, Assemblyman Justin Watkins, for the record. Correct.
I think he was looking for the word affirmative, but we'll go with correct. I don't see any additional questions at this time. So we'll go ahead and open it up for testimony. So beginning here in Carson City, anyone that would like to testify in support of Senate Bill 303, please come forward. Not seeing anyone and not seeing anyone in Las Vegas. Broadcasting, will you open the lines?
The public line is open and working. There are no callers at this time.
Okay, thank you. Then I'll go ahead and open it up for opposition testimony, beginning here in Carson City. Not seeing, oh,
Good morning.
Good
Matt
morning.
Walker on behalf of Howard Hughes. We are in opposition today in the bill as presented. We're still absorbing the amendment. Mr. Watkins and the Justice Association has been kind enough to continue a dialogue as Summerlin develops large-scale recreational infrastructure such as our 200-plus mile trail system, 90-acre Grand Park, et cetera. And so we're still in conversation about how we can maintain the ability to deliver public safety, public infrastructure open to the public at no cost that functions similarly to some of the lands captured in the bill as redrafted, while still under the ownership of a master plan developer. And we appreciate their patience and diligence in continuing that conversation. Thank you.
Chair Miller and the members of the committee, for the record, my name's Tommy Ferraro here on behalf of Southern Nevada Home Builders Association.
could you please spell your name?
Last name Ferraro. SNHBA respectfully opposes SB 303 as amended. While we appreciate the intent of the bill, we are concerned that removing liability protections for private parks and residential common areas may have unintended consequences. We encourage further discussion to ensure that the community access and safety can be balanced without discouraging investment in shared spaces. Thank you.
Thank you so much. Is there anyone else that would like to oppose Senate Bill 303? Okay, not seeing anyone here in Carson or there in Las Vegas. Broadcasting, will you please open the lines?
Public lines are open and working. There are no callers at this time.
Okay, thank you. Then I will open it up for neutral testimony, beginning here in Carson City. Not seeing anyone here in Carson or in Las Vegas. Broadcasting, will you please open the lines?
The public lines are open and working. There are no callers at this time.
Okay, thank you so much. Then I will welcome the bill presenters up for any final remarks.
Thank you, Chair and members of the committee. Justin Watkins for the record. Thank you for your time and your indulgence with the late amendments. I'd be remiss if I didn't extend my gratitude to all the cities and counties and state entities that have worked with me so hard on coming up with this language. And as indicated, I will continue the conversations with those in opposition to see if there is a way that we can both promote good public policy in development of recreational opportunities for the state of Nevada, while also developing good public policy to ensure safety standards are met. Thank you.
Thank you so much. And with that, I will go ahead and close the hearing on Senate Bill 303. Next, we have Senate Bill 359, which makes various changes relating to traffic offenses. So, Senator, we'll give them a moment to Whenever you're ready, Senator, please proceed.
Good morning, everybody. Melanie Scheibel, State Senate, District 9. Thank you for allowing me back in front of the Assembly Judiciary Committee. This isn't even my last presentation in front of you. We're just in the middle, you guys. And I'm very happy to be here presenting SB 359. SB 359 is another follow-up bill to AB 116 of the 2021 session, which decriminalized minor traffic offenses. And I stand by our decision to decriminalize minor traffic offenses. It is the right thing to do. It is good for Nevadans. And in doing that, we have to develop a process for handling these new civil infractions. Over the past 4 years, I have been working in the courts and with the courts to kind of figure out some of the successes and pitfalls of the ways that we have been handling them and figure out ways moving forward that we can do even better. So I have in front of me my copy of SB 359. I also have a copy of the amendment that you should all have. And I'm going to walk through them together so that we are all on the same page about what the proposal is. You'll notice the amendment comes from Clark County. They have been fantastic partners in getting a whole group of stakeholders together to try to make sure that we make this policy as good as it can be. So just kind of by way of background, I did work with representatives from Clark County, representatives from the Clark County District Attorney's Office, the District Attorneys Association, representatives from Washoe County, from the 2nd Judicial District, so the Washoe Courts, the 8th Judicial District, so the Clark County Courts, the judges of limited jurisdiction, so the Justice Court, Justice of the Peace, and municipal judges throughout the rest of the state, the City of Henderson, the Henderson City Attorney's Office, the Supreme Court, and public defenders from Washoe County. I also, I don't remember having Metro at the table, but I know I've discussed this amendment with representatives from Las Vegas Metro, so we've really tried to include everybody, and certainly there may be additional stakeholders who have feedback and input that I'm more than happy to accept, but I wanted to give you guys that background before I walk through the bill with you. Okay, so starting with Section 1. Section 1 is pretty meaty. It adds a whole new section to Chapter 484A of the Nevada Revised Statutes. 484A of the Nevada Revised Statutes is the civil infraction statute. And for the new section that we're adding outlines the process for having a contested hearing on a civil infraction. So at this point in session, you all are familiar with a number of different kinds of hearings. You know what a preliminary hearing is. You're familiar with eviction hearings, summary eviction hearings, evidentiary hearings. Well, another hearing that the court conducts is a contested hearing on a civil infraction. So if I were driving 10 miles over the speed limit, which obviously I would never do, I would, but I haven't. If I were driving 10 miles over the speed limit and got a ticket for driving 10 miles over the speed limit, and my ticket was handed to me personally, it has we'll just say instructions on it for how to handle the ticket, but let's say for whatever reason I want to fight the ticket. I don't think I was going 10 miles an hour over. I think that there's something else wrong with the ticket. Maybe I'm looking at it and I can see that they have the wrong make and model of my car. The ticket's not in my name. There's something wrong with it. I want to contest the ticket. Much to my client's chagrin, there is no process to simply tell the court that they're wrong and get your ticket dismissed. You, in fact, have to have a hearing. And so Section 1 of the bill outlines how that hearing is supposed to be processed. So if we look at Section 1 and we look at the proposed amendment, the amendment, let's read through the amendment to understand the process that we're agreeing should be in place for civil infractions. So the hearing should be conducted by any court. We're removing magistrate and replacing that with court. And it should follow the rules that are adopted by the Nevada Supreme Court. And if you move to the second page, we're going to allow anybody to acquire a subpoena. So that could be the prosecuting attorney for the state or the city. That could be the attorney for the person who's contesting the ticket, or the person who's contesting the ticket themselves. A subpoena, as I'm sure you know, is basically a strongly worded letter to a witness that tells them to come to court. In pretty much every court, there's a process for obtaining a subpoena. If I'm a private citizen, I'm contesting my speeding ticket. Generally, there's a form I fill out. I apply to the court and I say, hey, court, will you please tell, Greg Baylor to show up in court on March 5th. He's my witness. And the court will then issue a subpoena. So the reference to the Supreme Court rules allows for the courts to develop their own rules for how a person makes that request. Subsection 3 clarifies that at the hearing, evidence can be taken only after somebody has been sworn in and make an oath to be truthful. Every party can call their witnesses, introduce exhibits, cross-examine witnesses, and offer rebuttal evidence. Subsection C here, which you see in green, and I want you to look at the amendment because in purple is what was in the original bill, in green is what we're suggesting to replace it with, is simply a statement about the rules of evidence that apply in a contested civil procedure or in a contested civil infraction hearing. Because we have had confusion in the courts about how they're supposed to conduct these hearings, and they are not trials. The standard of proof is not the same as a trial because nobody is going to end up with a criminal conviction at the end of the case. So nothing has to be proved beyond a reasonable doubt. It only has to be proved by a preponderance of the evidence, which means that a lot of the trial rules that we have for criminal procedure do not apply to a civil infraction. And so subsection C is language that is borrowed from, I believe, Arizona's civil infraction statute, indicating that it is a less formal proceeding than a trial on a criminal case, and that the acceptance or admission of evidence is up to the judge. It has to have, this is kind of the heart of the subsection C, it has to have probative value to a fact at issue. So essentially it has to be relevant to the case, and the judge gets to make the determination of whether or not it is probative, whether or not it is reasonable, whether or not it's the kind of evidence that a normal person would rely on. So that gives the court the ability to say, this evidence doesn't rise to the level of being reliable enough for me to utilize it. Or it allows the court to say, I understand this is not a criminal proceeding. I don't expect you to bring in an expert to testify to whatever it is you're arguing. I will accept your representations as evidence. Subsection 4 allows for hearings by phone or by video, and that is section 1. Section 2 of the bill, if you look at the bill itself, it only had one little teeny tiny change down on line 27, changing a may to a must, but the courts caught me. And so we had to expand this section. I kid, they really were great partners. And so what we've done in the new section 2 is clarify what happens when a person has both a civil infraction and a criminal complaint at the same time. I will also say personally that this has happened a lot more than any of us expected. I don't have the courts may have the numbers, but when we discussed this back in 2021 when we were passing AB 116, we threw in this section 2, like, oh, I guess that could happen. And now it's a daily occurrence in both Washoe and Clark County. So we had to figure out how to deal with it. And this is what we have come up with. We want the two cases to stay together, the civil infraction and the criminal complaint. I think a really common example of this is when somebody is cited for reckless driving or for having expired insurance or not having insurance. Those two are both criminal citations, but often that also comes with something like failure to signal or having a broken tail light or talking on the phone while you're driving. So someone gets pulled over for using their cell phone, which is a civil infraction. And then they get hit with that criminal citation for not having insurance or not having a license. So what we propose to do in Section 2 is allow for those to be consolidated into a single complaint. The issue with requiring them to be consolidated was that it was a couple of issues with some courts being unwilling, some courts being unable to combine those due to technological restraints. But basically, we are encouraging the courts to keep them together. And in order to facilitate that, what Section 2 says is that they can be consolidated at any point in the proceedings on the motion of a party or the court's own motion. That consolidation doesn't even necessarily have to mean that the complaints are going to be combined into a single document. It can just be the criminal complaint and then the civil complaint, numbers 4 and 5 on the judge's docket that day. The really important part is that if there's going to be a hearing on them, that's where subsections A and B come into play. What we're envisioning is that judges will be able to hear the evidence on both infractions at the same time. Because the criminal infraction has to be proved beyond a reasonable doubt, the criminal procedure rules would apply. So the court would hold a full trial. Witnesses would have to be sworn. There would be no admissible hearsay. The judges would have to follow the rules of criminal procedure when it comes to allowing witnesses to testify, when it comes to evaluating the probative value of evidence and making a determination. However, the standard of proof will still remain only a preponderance of the evidence for the civil infraction. So, in practice, what this would look like is if somebody is contesting their ticket in its entirety, the court would hold a trial. The prosecuting attorney or we'll go with prosecuting attorney would bring in the evidence that the person was driving without insurance. They would also present any evidence they have at the time of the broken tail light. And then the judge would make a determination on both of them. In order to find the person guilty of driving without insurance, that would have to have been proved beyond a reasonable doubt. In order to find them responsible for driving with a broken taillight, that would only have to be proved by preponderance of the evidence. This is something that judges do every single day. Like we just talked about, there are 100 different kinds of hearings, and throughout the state of Nevada, judges preside over eviction cases and preliminary hearings and bail hearings and evidentiary hearings and calendar calls and motions to dismiss every day, and those all have different standards. So judges are very accustomed to having one standard for one kind of case and a different standard of proof for a different case. Here, what's a little bit unique is that they're taking all of the evidence at once, because the alternative would be to present all of the evidence, close the hearing, or close the trial, open up the hearing, and present all of the same evidence. And so we're not going to make the courts do that. So that is what Section 2 does of the bill. Moving on. Oh, sorry. And there's also subsection 3 talks about hearing those things at the same time, which I think I already explained. Section 3 of the bill we're not making any changes with the amendment. So Section 3 is really just conforming changes to allow for the cities and the counties and the state to issue these citations, which they're already doing. On to Section 4. Section 4 pertains to the bond that somebody has to post in order to get one of these hearings on a civil infraction. Currently, that bond is being set at the amount of the citation. So if I got that civil infraction citation for talking on my cell phone, I would have the option to either pay a $250 fine or post a $250 bond and get a court date. And so Section 4 allows for those bonds to be set at a lower amount so that you're not paying the whole fine and then going to court, and if you win, getting reimbursed. Section 4 also allows a prosecuting attorney to represent the state. Subsection 3 of Section 4, if you're looking at the amendment, because this is not in the original bill, so subsection 3 of Section 4 is on page 6 of the amendment, has an important stipulation in it. It allows an attorney to appear on behalf of their client in a trial or in contesting a civil infraction, and it clarifies that by doing that, the person who chooses not to come to court and instead have their attorney appear for them stipulates that they are the person who received the citation. So as an attorney, I couldn't go to court without my client and then argue, oh, my client's name is Joe Smith, but my client isn't Joe Smith. So you gave the citation to the wrong person. If you're going to argue identity, you have to be there. That's what subsection 3 says. Subsection 4, we did make that change about the subpoenas because we put the subpoena power in section 1. And then section 5 is clarifying that for peace officers, they basically have two choices when it comes to these civil infractions. They can either fill out the affidavit that explains the evidence they would have presented in court, or they can come to court. If they choose to do neither of those, the judge can dismiss the case unless there's other evidence, like a third-party witness who comes to testify. This has been an issue, at least in Clark County. We think it's because there's just a little bit, again, a lack of clarity on how these hearings are supposed to work. And we're hoping that the purpose here is to try to make it clear that there are two options. If you're a peace officer and you issue a citation to somebody for talking on a cell phone, not signaling properly, and you want that citation to stick, you either have to show up or you have to respond by mail to the form that the judge sends you. And if you don't do either of those things, be prepared for your case to be dismissed, and you can't complain about it. That's essentially what that part says. We added a subsection 8 to section 4, clarifying that nobody will be awarded attorney's fees. Even though these are civil cases, we're not going to do attorney's fees on traffic tickets. Section 5, we're getting close, I promise. Section 5 is really just conforming changes, and Section 5 clarifies that if the prosecuting attorney, it clarifies that if the prosecuting attorney wants to reduce a criminal charge down to a civil infraction, they can do that at any point. So, for example, they might want to negotiate a criminal citation down to a civil infraction. It is something that my clients only ask me to do every single day, 3 times a day. But the statute wasn't clear that a prosecutor could do that at any point during the case, so we removed that language that you see removed in the bill. It's like lines 32 through the end of the bill. On the amendment, it's pages 7 and 8. We removed that language about having to do it in advance, so they can do it at any time. We also added a subsection 6, which clarifies how the money is to be collected by either the municipal court or the justice court pursuant to this section. And we also added a section 7, which pertains to DUI charges. And basically what section 7 says is if the civil infractions arise out of a DUI and that DUI is ultimately dismissed, then the civil infractions, anything that was criminal has to be reduced to a civil infraction in that case, if it's not dismissed entirely. And we also added a Section 8. Section 8 gives the counties, so the counties already have the ability to create traffic rules and to create misdemeanor traffic offenses. It wasn't clear if they had the ability to create civil infractions, so it only seems fair if we're going to allow them to impose criminal penalties for traffic violations, we should also allow them to impose civil penalties for traffic infractions. Section 8 gives them that that power. Section 9, allows for the case where someone is not contesting the ticket. So okay. So, sorry. I had to make sure I was clear on which section this was. So the courts and the prosecutors have been desiring to allow people to plead online, to plead without going in front of a judge, to streamline their process, and still allow people the benefit of the bargain of reducing their citations from criminal infractions or criminal citations to civil infractions. Section 9 would allow them to do that. And then they can pay everything before the due date and get their case closed so that the court doesn't have to wait the full 90 days that someone's entitled to if they want to close their case out earlier. And I think that covers the main, if not all, sections of the bill.
Are you sure?
No.
Okay, so,
There are no questions, right?
I'm waiting to see, but, I had to log back in. I don't think there actually are any questions.
I see one.
Assemblymember Cole?
Thank you for the presentation. I think this is kind of a neat cleanup bill based on like real life and what you've experienced. So my question is on page 2 at the top where we're talking about who can get the subpoenas. I'm curious as to in what situations would the court be issuing subpoenas in these cases? Thank you.
Melanie Scheibel, for the record, great question. The court could, if they felt it was appropriate, develop a system where if the prosecutor doesn't want to come to court for the contested hearing, the court could issue a subpoena to the peace officer to appear. Because we've been trying to figure out if the prosecuting, so if peace officer issues a citation, person who is cited goes and gets a court date. If a prosecutor is not going to be involved, and some of them don't want to be involved, how in the world is that peace officer supposed to know about the court date? At this point in time, I'm not aware of any courts that are issuing the subpoenas themselves, but this would allow for that process if that's how they wanted to fashion their system.
Assemblymember Nadeem?
Thank you so much, Madam Chair. Thank you for the presentation. So my question, if there are two hearings together, the civil hearing and the criminal hearing, what is the benefit of it? Is that going to save the court time and the person who's been responsible for this? How does it go?
Melanie Scheibel, for the record, exactly. It saves the court time. It saves the person who's contesting their ticket time. It also prevents an issue which we've been seeing where people have two different court dates and they actually don't realize it. So they go to the first one, they think everything is taken care of, and they miss their second court date. And so by having them together, we'll avoid that oversight.
Thank you.
Thank you. Our next question is from Assemblymember Hanson.
Thank you, Chair. Thank you for being here, and I appreciate one of my, a really great bill explanation of going through the section, so thank you. You remind me of your dad, who was a good teacher. So Anyway, in regards to section, and as part of AB 116, remember it well, supported it. Glad to see, we see how this plays out. Sometimes we need to come back and fix things, and so appreciate that. In section 7, if you could just, I think I just need an actual example to help me understand it. Section 7, the very first part where this is about driving while under the influence of alcohol, unless pursuant to plea negotiation. If the charge of driving while under the influence of alcohol and/or a controlled substance or prohibited substance is dismissed, I get that part, or reduced, any civil infraction charged as a misdemeanor shall be reduced to a civil infraction. Could you just clarify that for me? Maybe give a specific example where that happens.
Yes, thank you. So, I'm trying to think of a fact pattern. I'm kind of looking in the audience for the people who provided this language to me. But, I definitely have clients who are stopped for DUIs and also have those insurance infractions. Maybe there's a speeding infraction involved. And so if they're originally charged with a misdemeanor DUI and a misdemeanor speeding, if the DUI is dismissed, then pursuant to Section 7, that speeding should also be reduced to the civil speeding infraction.
Okay. Thank you so much. Then I will go ahead and open it up for testimony. We will start here in Carson City, beginning with anyone that would like to testify in support of Senate Bill 359.
Good morning, and thank you, Chair Miller and committee members. My name is Nick Shepak, Nickshepak. I am the Nevada State Director of the Fines and Fees Justice Center. We are here today in support of SB 359. Last session, we passed bipartisan legislation that would have ended the bond. However, that was vetoed by the governor, so this piece of legislation takes an important step in dealing with a bond that we don't believe should exist, but understand due to the political climate, we need to take baby steps. We believe that courts that are good actors will, in fact, reduce this bond and make it easier for individuals who are seeking to challenge their tickets but maybe don't have the money or the wherewithal to go through the process to ask for a reduction, to actually pay that bond and be able to challenge that ticket. So this bill is a good step in that direction. We appreciate the sponsors' work on all other sections, especially the ability to turn a criminal traffic citation into a civil citation, which is something we've hoped to see for a long time. For those reasons, we support. Thank you.
Thank you, Chair, members of the committee. For the record, Mike Cathcart representing the city of Henderson, CATHCART. Just want to thank the senator for convening the working group. I believe we've gotten to a really good piece of legislation. I also want to thank Mr. Rogan, who's sitting here with me, that all the work he has done on this bill as well. Thank you.
Good morning, Chair Miller and members of the Assembly Judiciary Committee. Jeff Rogan, JEFFROGAN, on behalf of Clark County. As has already been alluded to, there was a lot of people that were involved in this. It's a very dry bill, but it's a very important bill because for the last 4 years or so, we've been finding issues that have come up that we didn't anticipate when we decriminalized a lot of these traffic tickets. And so everyone had their stake in this, and so what you see is just all of the issues that have arisen we've attempted to resolve, and I'm sure we'll probably be back in front of you next session with some more. So again, thank you so much for the senator for putting in the hard work on this and all the other municipalities and as well as the courts. Thank you.
Thank you so much. I don't know, it seems like you covered every tedious scenario you could. Seems like it, I know. Is there anyone else here in Carson City that would like to testify in support? Not seeing anyone here or in Las Vegas. Broadcasting, will you please open the line?
If you would like to testify in support of Senate Bill 359, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 359, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Okay, thank you. Then I will open it up for opposition testimony. If there's anyone here in Carson City that would like to oppose Senate Bill 359, Not seeing anyone here or in Las Vegas. Broadcasting, will you open the line?
If you would like to testify in opposition to Senate Bill 359, please press star 9 now to take your place in the queue. Again, if you would like to testify in opposition to Senate Bill 359, please press star 9 now. Chair, there are no callers wishing to testify in opposition at this time.
Okay, thank you. Then I will open it up for neutral testimony.
Good morning, Angela Knott from the Washoe County Public Defender's Office, ANGELAKNOTT. We are neutral today with SB 359. We were originally in opposition because of the mandatory language in Section 2. Since that is now permissive, we have removed our opposition, though I'm still very intrigued to see how the process will really work with the real practice of the Washoe County Public Defender's Office in balancing both a criminal complaint and a civil infraction, but we remain neutral and we're very thankful for the senator for all the other sections of this bill. Thank you.
Thank you. Is there anyone else here in neutral? Broadcasting, will you open the lines?
If you would like to testify in neutral for Senate Bill 359, please press star 9 now to take your place in the queue. Again, if you would like to testify neutral for Senate Bill 359, please press star 9 now. Chair, there are no callers wishing to testify neutral at this time.
Okay, thank you. Then I will welcome, and the senator has nothing else to say on this bill, so I will go ahead and close the hearing on Senate Bill 359. Lastly, we have Senate Bill 406, which revises provisions relating to civil liability. And with that, I'll give you a few moments as the room clears.
Appreciate it.
Mm-hmm. Usually the room doesn't clear as quickly after each individual bill, but with that, your bill hearing is open, so please proceed when you're ready.
Chair Miller, members of the committee, thank you for having me today. Jimmy Martinez, Chief General Counsel for ENCHI, last name Martines, and I'm here to present SB 406. And what I would like to do this morning is first kind of run over why this bill is important, give you some background, and then get into exactly what the bill does. And afterwards get into a little bit about what the bill does not do. So I'm sure everybody remembers spring 2020, COVID pandemic, governor's orders, federal orders, we were required to shut down all of our institutions of higher education. What we did at that point was, as so many other institutions across the country, is all education moved to remote learning. We were provided tort immunity by the legislature at that time. What we were not provided was contract immunity for compliance with the government orders. So what happened was there have been over 200 class action lawsuits filed across the country alleging that students had quasi-contracts for in-person learning when they paid their tuitions and fees, and those class action lawsuits are demanding repayment of all tuition and fees for all students that were enrolled at that time. What this bill does is it provides immunity for compliance with the governmental orders. So briefly, exactly how does it do that? It's providing a very limited immunity for very specific purposes. So when I say that, I mean this is only immunity for claims arising out of tuition and fees paid only during the spring 2020 semester. It's also only for money damages, and it's also only for acts and omissions that are one, that took place during the 2020 spring academic semester, that were reasonably related to public health and safety, and that were performed in good faith efforts to comply with the COVID-19 declaration of emergency and subsequent orders and directives. The bill also sets forth the compelling state interests that are the public policy points that we wanted to point out in the bill. And those are to protect the state treasury, to ensure the stability and sustainability of our higher education institutions, And for me, what I think is one of the most important ones is encouraging future compliance with governmental orders in public health crises. So turning quickly to what the bill does not do. The bill does not create immunity for vaccines or decisions made around vaccines. Does not create immunity for any physical harm or torts. It does not create immunity for equitable remedies. And it does not create immunity for acts and omissions that were not in compliance with a government directive at that time. So I know I went through that really quickly, but I just wanted to say that it's a fairly short bill. There's not a lot to go through, but we don't take asking for immunity lightly. This is a reasonable bill that is very narrowly tailored to achieve compelling state interests, and this bill will ensure that institutions in the future continue to follow government orders in public health crises. And we're not setting public policy that says, in a public health crisis, here are the government orders, but comply at your own risk. And with that, I'm happy to answer any questions and ask for the committee support.
Thank you so much. I just have a few clarifying questions first. So I remember the exact date. It was Friday, March 13th, when at least CCSD shut down. And I remember that I was actually at CCSD headquarters that day. So I remember it was March 13th, but I know that college and university, often their semester is shorter than what K through 12 is. So when was, since you're saying this is just the spring semester.
Correct.
When did that spring semester end? What was the date?
Jimmy Martinez for the record. I don't have the exact date, but the spring semester would have ended, I believe, in May.
In May. The beginning of May or end of May?
I may have to phone a friend.
Okay. Because I know most of our K through 12 in the state are now done before Memorial Day. So I'm just wondering. Yes.
Certainly. For the record, Patricia Charlton, Chancellor, Nevada System of Higher Education. Our typical spring semester ends on or about the middle of May. Commencement season is in full bloom, beginning even this week, so it's usually around that time. There may be some classes, particularly it happens in the allied health area, that may continue through the end of May, just because of the clinical coordinating hours that students have to participate in.
Thank you for that. And we are just talking, you mentioned it in your presentation, we're just talking about immunity for following the government instruction. Can I ask another question? Were there students that, I guess, I'll wait, I'll follow up in case members ask it. I'll let members, we'll go to members' questions. So let's start with Assemblymember LaRue Hatch.
Thank you, Chair. Thank you so much for bringing this. I was also a teacher I still am a teacher, but I was a teacher when this broke out and we went on the never-ending spring break because Washoe was on spring break and we just never came back. And I remember at that time that it was confusing and there was suddenly government mandates and are we going back or are we not? It was a very fluid situation. So I understand what you're talking about. My question is, why is this immunity only for that spring 2020 semester? We know that COVID lasted longer than that. So what are you targeting about that semester specifically?
Jimmy Martinez for the record. Great question. The reason why we're only targeting that one semester is because that's the only semester where students didn't have advance notice that we were moving to remote learning. Every semester after that, when they enrolled, it was clear that they were enrolling only for remote classes.
Thank you. Our next question is from Assemblymember Cole.
Thank you, Chair. Similarly, my son was actually in college when this happened. He was at NAU, so I don't know if they're experiencing the same issues or not, probably. But my question has to do with sections 3 and 4, where we're talking about the retroactive application to current litigation. So I'm just curious as to how this will work, how this will help for you in practice, and if that ties into the level of scrutiny that we're talking about, because I noticed we've got some intermediate scrutiny going on in the first section. Thank you.
Great question. Jimmy Martinez for the record. This is retroactive immunity for any claims that are not final on the date that it's enacted. So what that means is it's retroactive for any of those claims. It also sunsets within 5 years. So there's a clear end date for the immunity as well. We made this bill very, very narrowly tailored specifically to overcome constitutional scrutiny. So as you can see, it's only for very specific limited circumstances. The governmental interest is very clear, so we're confident that this bill will survive constitutional scrutiny. It's also been addressed in other parts of the country. The First Circuit has ruled that the retroactivity is permissible in this format, and we're hoping to get the similar rulings in Nevada if it's challenged.
Our next question is from Assemblymember Gray.
Good morning, sir, and thank you for meeting with me. The other day, got a lot of information. One of the questions come up for me, though, is actual damages. Has anybody been able to prove that because of the breach of contract, that their education was actually harmed? I mean, have they compared grades across anything? I mean, it's one thing to breach, but it's another thing to prove damages.
Jimmy Martinez for the record. Great question. Short answer is no. We've been in litigation. We're still in discovery. We're still challenging the fact that there is a contract. So, it would be a long time before we get the damages, but when we do get the damages, I don't want to talk too much about the ongoing litigation, but damages is a very complex issue with these types of cases across the country, because you're certifying a class treating all students exactly the same. Students still received credits. Many students graduated. These are all things that were of value that students received. So, and what students paid in terms of tuition and fees is going to be different for all students across the state. So it's a very complicated issue. I think if we were to get there, it would take a long time in sustained litigation to get those answers. And I think that's why we see so many settlements across the country in these types of cases. They're just very complicated.
All right, thank you. Our next question is from Assemblymember Gonzalez.
Thank you, Chair. Good morning. Thank you so much for the presentation. I was also a student during this time, and it's very, I struggled a lot with online education. And so my question is, and you spoke to about national settlements and national litigation, but are there any current pending litigation in any of our NSHE institutions for this?
Great question. Jimmy Martinez for the record. Yes, we do have one case that we're currently litigating in the state. It's the only case right now. There could potentially be others, but that's the reason why we're bringing this bill at this time, because we think it's ripe. We've seen some good outcomes throughout the country, some common sense bills that have come out of other states that really help protect the state's coffers and set good public policy.
Yes.
Thank you so much. And then I'm just trying to understand, because I'm also not a lawyer, but I love this committee. And so when we implement this, would that bar anyone who comes forward once this bill passes, if this bill were to pass, from being able to receive damages for that claim?
Jimmy Martinez for the record. It would provide us immunity like the other immunity statutes, so it would be something that we would they could still file a complaint. We would just have to then plead the defense of immunity. So yes, it would prevent them from getting damages, but again, only in those very limited circumstances that are set forth in the bill.
You're welcome. Our next question is from Assemblymember Hansen.
Thank you, Chair. Thank you for being here. And I think all of us have that. We measure life now in terms of pre-9/11, post-9/11, and unfortunately now pre-COVID, post-COVID. So yeah, this is all fresh in our memories. I am very grateful that this is very narrow. It's just that semester, which, if I recall, is like the end of January till about the middle of May. For the most part, for the university systems or the school systems. So one case in Nevada, but I think you mentioned multiple in the United States. And just to clarify, these are taxpayer dollars that will pay these class action lawsuits if they're settled or they go to court, but it seems like most class actions sometimes get settled. So for a student who's claiming it wants to recover, they're not going to get 100% back if they're part of these cases, right? I think, I don't know if you can answer this, but in a class action lawsuit, the attorneys might recover anywhere from 40 to 60% of, say, the tuition if the student didn't get that back. But did students get their money back that asked for it in this time frame?
Jimmy Martinez for the record. So I think there were two questions there. One related to the amount that in class action lawsuits that go back to the plaintiff class. I can't speak to any case exactly what the plaintiff's lawyers have negotiated in their contracts or what their fees ultimately may be, but I think we all have general knowledge of class action lawsuits, and many of us have been in them, and we see what our checks are at the end of the day. I think a lot of it is eaten up by costs and attorney's fees. The second question, when it comes to I believe the next question was, were students able to drop and get refunds? All of our institutions have refund policies, drop dates. During this semester, those strict deadlines for drop dates and refunds were all waived. So I'm not aware of any students that requested to drop and not continue their courses online who were denied. So those were administrative remedies that, to go to Assemblymember Gray's question previously, when we talk about damages, that's a big part of that conversation also. When you certify a class like this, how many of the class actually exhausted their administrative remedies to get refunds at that time?
Thank you, Chair.
Thank you so much. Our next question is from Assemblymember Nadeem.
Thank you, Madam Chair. Thank you for the presentation. So my question is that what is the current situation regarding the other states? Regarding, do they get the immunity, or they're still fighting, not the institutions and not a particular college or the institute? It's regarding the states.
Jimmy Martinez for the record. Great question. Our bill is closely based on the state of Massachusetts. They've had the most favorable outcomes in the state of Massachusetts. They were able to get their case dismissed, and it was upheld by the First Circuit. And we've got some good case law out of the First Circuit that we're hoping to cite in anything that comes out of this bill.
Thank you.
Now it is working. Our next question is from Assemblymember Roth.
Thank you, Chair, and thank you so much for the presentation. I'm hoping you can just tie back in the really public policy purpose of this bill. And looking in Section 1, there's the declaration, the legislative declaration of the purpose of this. So can you just speak to that a little bit more in why we need to ensure that our institutions of higher education can respond to any future health crises?
Absolutely. Jimmy Martinez for the record. Great question. It's really important for me to make sure that we're setting good policy and everybody understands the public policy points that we're really trying to make here. So there's three set forth in the bill. One, obviously, we're a state entity. So the legislature approves our budget, we don't have millions of dollars in profits that we are, holding on to. It's all taxpayer dollars. So if we were to continue these types of cases and we did have a judgment of some sort, we would be back to the legislature asking for funds and appropriations for that purpose instead of asking for immunity to resolve the situation. The most important one, I think, is, as you stated, allowing institutions to comply with government orders and still not be liable for it. And I think the legislature did that in the special session when tort immunity was granted. We kind of saw where liability was open to us. We knew we had to comply with these orders. People could get COVID by being in the same place. There were certain things we couldn't control, and immunity was granted. In hindsight, I think had we known these situations would arise, the legislature would have probably granted contract immunity for strict compliance also. Finally, the reason why I think it's really important is we're talking about contracts alleging breach, which the strict compliance of the contract was impossible. And of course, that's part of the litigation as well. But litigation costs money. It costs taxpayer dollars, and it's significant. And by coming here and trying to ask the legislature to make good policy when it comes to the expenditure of these types of dollars in this specific situation, I think this is setting good public policy.
Thank you for that. We have another question from Assemblymember Gray.
So, sir, going to the litigants of this case and restating the facts, followed by a question of this. So right now, the litigants are a single plaintiff represented by a law firm that is saying it's a class action suit, which has not been certified as class action, and then the defendant is NSHE. My question is why is the defendant NSHE when they were forced to break the contract by the governor's office? Why isn't the governor's office or the former governor's office been named as a defendant?
Jimmy Martinez, for the record, the short answer to that is because that's who they named. I would anticipate that as this litigation proceeds, I think the state may be named as a necessary party in the litigation as we get through those arguments of impossibility. But as of right now, we haven't pushed the issue to kind of force the state into it. I think that may not be the best thing for NSHE to do in terms of our camaraderie with our state. So ultimately, though, I do think that those are valid questions in the litigation, and I think at some point, if the litigation continues, then we would have to get into those questions of necessary parties.
All right, thank you. So many members did touch upon or responses were given to their questions. So I did hear that, students still had the opportunity to earn that credit. And did I also hear that, well, maybe I should ask specifically, during that spring semester, if students were like, because I know in many situations, I had coworkers that were like, that's it, I'm retiring. There's no way I can turn on a dime and do this online. So I imagine, obviously, college is by choice as opposed to K through 12. Were there students who did decide to withdraw for that semester? I imagine because it was almost a month before the end of the semester that it would probably be past the withdrawal dates. So I'm just wondering, how did this colleges and universities handle that?
Jimmy Martinez, for the record, I do know that there were students that chose to drop and withdraw when we were moving remote. I don't have numbers. If that's something that you would like me to request, I can do so from the institutions. But the short answer is yes. There were students who withdrew for whatever reason. They didn't want to continue remote. But remote learning wasn't a cost-saving measure by any means for these institutions. You know, it was more expensive to change on a dime and implement new ways of instruction.
Thank you for that. And I don't need necessarily the numbers of students who withdrew. I'm just getting at, were they allowed to without penalty? Because I know there's a point where, or there was, it's been a while, where you can withdraw without it impacting your grade. So I get, and you know, obviously withdraw with full refund. So I'm just wondering if students were able to do so.
Certainly, for the record, Patricia Charlton, Chancellor, Nevada System of Higher Education. Yes, our Board of Regents actually implemented policy during that time in which students for that spring semester could file appeals and modified refund processes if the student considered that that would be in their best interest.
Okay, thank you for that. One last question too. So during your presentation, you brought up a breach of contract. Can you explain what this contract is that the class action lawsuit is referring to?
Yes, Jimmy Martinez for the record. This is a quasi-contract, so there's no written contract anywhere. The allegations across the country are these are quasi-contracts for in-person learning, and the institutions of higher education breached that contract when they moved to remote learning. The allegations are also to the effect that every pamphlet that showed a facility, any advertisement, these are all things that students relied on for their payment of tuition and fees, and therefore they are all part of this contract. So you can imagine with 8 institutions across the state and many, many pamphlets and advertisements of what each school offers, the discovery on going through every document that may or may not be part of a quasi-contract can be voluminous.
Okay, thank you for that. I know that that month or so leading up to COVID, I was teaching English, and I had my 6th graders. All my classes read Fever 1872, about a epidemic, you know, true story of an epidemic that broke out. And then I had another class reading The Fun They Had. That's a very dystopian story about schools being eliminated and students being taught completely by robots. And then I had my debate class debate the idea of virtual and online learning versus traditional classroom learning. So when the epidemic did hit and the schools did close down, all my students thought that I somehow knew that this was going to happen. Is this why you prepared us with these stories? And I was like, absolutely not. I had no idea any of this was coming. So, but also reminded them, but you do have a foundation on this, and you already took a position on where you felt about what you felt about virtual learning. So at the end of, we had like 2 months left, we were able to revisit where the students, their original positions from debate on where they landed on virtual learning. So with that, not seeing any additional questions. Oh, Assemblymember Hanson.
Thank you, Chair. I'm sorry I messaged you, but thank you for one last question that just came to mind. So we talk about this has been narrowed very specifically to that semester. And I know I'm going to bring up the V word and that hornet's nest. So the reason this is important is it just deals with students impacted in that semester. For those who had concerns over a mandate on the COVID vaccine to be a student, that did not come until December 31 of 2021, correct?
Jimmy Martinez for the record. That's correct.
And that's a separate issue, that if a student or people have a problem, has that since been repealed?
Jimmy Martinez for the record. One thing that the Board of Regents never had authority to do was address student vaccines. That was all done at the state level. So that was never anything we dealt with anyway, but I believe those, they were implemented and then it was repealed thereafter.
Thank you. I just wanted to clarify those timeframes and who has the authority to make those decisions. Thank you.
Okay, so one last question too. When did you, because again, I'm judging this through the K through 12 lens, when were the classrooms or the physical space for the colleges and universities open again?
Jimmy Martinez for the record. I may go to our chancellor for that
Sure.
question as well.
Certainly for the record, Patricia Charlton, Chancellor, Nevada System of Higher Education. So we actually received guidance in probably late May, early June, that for certain programs of study, those that were high demand, such as certain healthcare, EMS, public safety, because of the nature of those first responders, that we were able to begin to bring them back into the learning space. However, had to do that with all of the requirements regarding social distancing, mask wearing, etc. And so we began that in the summer of 2020 because we had to actually modify classroom spaces, and in some cases we were not able to get PPE for those individuals and those students that needed to be on campus. And so we were able to begin in June for certain programs of study that were actually listed in directives from communication, I think via a letter from the governor. And then we had already began implementation of some balance for the fall of 2020, again, making those classroom modifications, because we actually had to take our normal class size, which could be an average of 25, and no longer could have 25 individuals because our rooms were at basically fire code. And so we had to remodify classroom spaces in order to bring some of those classes back in the fall.
Thank you so much for that. And did I just hear class sizes of 25? Yeah, I guess I heard that, huh?
That's just one class size. However, some of our classes could be upwards of 300 students.
Okay, thank you. With that, I'll go ahead and open it up for support, beginning here in Carson City. So anyone wishing to testify in support of Senate Bill 406? Not seeing anyone? Here or in Las Vegas Broadcasting, will you open the lines, please?
If you would like to testify in support of Senate Bill 406, please press star 9 now to take your place in the queue. Again, if you would like to testify in support of Senate Bill 406, please press star 9 now. Chair, there are no callers wishing to testify in support at this time.
Thank you so much. Then I'll open it up for opposition testimony, beginning here in Carson City.
Good morning, Chair Miller and committee members. My name is Jim DeGraffenreid, Jimdegraffenreid. I'm Nevada's Republican National Committeeman, here today on behalf of the Nevada Republican Party in opposition to Senate Bill 406. Senate Bill 406 is somewhat contradictory, simultaneously presented as a very narrowly tailored bill, but at the same time is a situation that can result in a large liability creating a compelling state interest. If the scope of the bill is truly narrow, then this very fact is an argument against the protection of the state treasury being a compelling interest, as added in Amendment 143. We greatly appreciate the concerns raised by Senator Krasner on this bill regarding the state interest and narrowness of the effect. Section 1, subsection 4 contains a long list of items that are covered beyond tuition, which argues against the bill being narrowly tailored. If the bill is indeed limited to actual monetary damages relating to tuition and fee estimates for a single semester in 2020, and if punitive damages are excluded, then it seems the dollar amounts involved would not rise to the level of a compelling state interest. We have serious concerns in general over providing immunity for actions taken during the 2020 pandemic response, as those actions have since been shown to be excessive and not evidence-based. Nevada's response was excessive compared to other states such as Florida and South Dakota, which followed a more evidence-based approach rather than the inconsistent and arbitrary response in Nevada. Anytime that a government takes excessive and arbitrary actions, as Nevada chose to do in 2020, citizens must have the ability to petition for redress of their grievances and damages. We're sympathetic that NSHE was acting on orders from the state, but unfortunately, due to other immunity, it seems like the contract actions may be the only avenue remaining for redress. If this is narrowly tailored, then it likely doesn't rise to the level of compelling interest, and we're opposed to setting any precedent for other government agencies to seek future immunity for inappropriate actions. Thank you.
Thank you. Is there anyone else here in Carson wishing to testify? Not seeing anyone here or in Las Vegas. Broadcasting, will you please open the lines?
If you would like to testify in opposition to Senate Bill 406, please press star 9 now to take your place in the queue.
Good morning, Chair and members of the committee. I'm Kimberly Fergus, Fergus. First, I would like to point out, does anybody read the public opinions? Because there's 100% on the no votes, and there's over 11 pages. However, my testimony is I stand in firm opposition to Senate Bill 406. This bill is retroactive shield for bad decisions made during COVID-19 pandemic. Decisions that disrupted students' lives, degraded their education, and drained families financially. University closed campuses, cut services, and delivered subpar instruction while charging full tuition. Now, this bill seeks to block students from pursuing justice through the courts. That's not protecting public health. That's protecting political mistakes. If those actions were justified, they should be defended in court, not erased by legislation. Immunity is not accountability. I urge you to vote no on SB 406. Have a good morning. Thank you.
Thank you. Next caller.
Cyrus, Hojjaty. Thank you for taking my call.
I'm sorry.
I will echo the previous.
I'm sorry, Cyrus. You didn't state your last name. I think you just spelled it. Could you state your last name and then spell it again, please?
Hojjaty.
Okay. Thank you. Please proceed.
Did I do it right, or?
Please proceed.
Yeah, I'll echo the previous and future callers. Thank you.
Thank you so much. Next caller.
Chair, there are no other callers choosing to testify in opposition at this time.
Thank you. Then I'll open it up for neutral testimony, beginning here in Carson City. Not seeing anyone here in Carson or in Las Vegas. Broadcasting, will you open the lines?
If you would like to testify in neutral for Senate Bill 406, please press star 9 now to take your place in the queue. Chair, there are no callers wishing to testify neutral at this time.
Thank you. Then I'll welcome the bill presenter up for any final remarks.
Thank you very much. Jimmy Martinez for the record. I think we've discussed a lot of the opposite points of the points that we just heard in opposition. When it comes to the state interests, the U.S. Supreme Court has spoke on this issue in General Motors Corp. versus Romaine. The U.S. Supreme Court determined that retroactive legislation must have a legitimate legislative purpose furthered by a rational means. When we look to the statements in the bill, I personally think that we can agree, even if there were arguments against whether or not these are compelling state interests. I do think they all are legitimate governmental interests, at least. Again, when it comes to any bad decisions or disagreements with the government orders that did come out, I would just reiterate, those were not our decisions. We were required to comply with the government orders. We did so, and I think it's bad public policy to say that we should be the institutions of higher education should be responsible for liability for such compliance.
Okay, thank you. And with that, I will go ahead and close the hearing on Senate Bill 406. Lastly, we have today public comment. So just a reminder, public comment is to make comment on anything under the purview of this committee, but not to discuss any of the bills that we actually heard today. And so with that, I will open it up for anyone here in Carson City wishing to make public comment. Not seeing anyone here or in Las Vegas. On broadcasting, will you please open the lines?
If you would like to provide public comment, please press star 9 now to take your place in the queue. Again, if you would like to provide public comment, please press star 9 now.
Anne Marie Grant, ANNEMARIE GRANT. Today I'm going to speak about the tragic and preventable death of my brother Thomas Purdy, who was asphyxiated while in the custody of Washoe County Sheriff's Office on October 4th, 2015. We removed him from life support on October 8th, 2015 because he was brain dead. Thomas was a devoted son and brother and my best friend, and his life should have never been cut short by those sworn to protect him. On the night of his murder at he was arrested at the Peppermill Casino for trespassing where he was a guest. Thomas was put in the rip hobble restraint in the hog tie position by Reno police against every page of the device manual that states never use to hog tie a human being. Despite repeatedly pleading, "I can't breathe," after over 40 minutes of being hog tied for, deputies got on his neck and back, murdering him. Video captured him begging for medical assistance, telling him that they were going to kill him and begging for help. "They're going to kill me. Please don't do this, guys, please." The Washoe County Medical Examiner ruled my brother's death a homicide due to complications of excited delirium and noted absent the positional restraint and force used against him by law enforcement, he would not have died. In 2021, the American Medical Association explicitly stated that the current evidence does not support excited delirium or excited delirium syndrome. The AMA opposes the use of these terms due to concerns about the term being used to justify excessive force, particularly in law enforcement. The cornerstone of our justice system is accountability, and when someone dies in state custody, there must be a transparent, impartial review and criminal charges from prosecution when appropriate. In Washoe County, this process has failed. The absence of any type of review for jail deaths creates a chilling message that deputies are above the law and that the lives of incarcerated individuals do not matter. Our family's wrongful death lawsuit resulted in monetary settlements, but money can not restore Thomas's life, nor can it substitute for criminal accountability. No family should
Okay,
endure what
Ms.
ours
Grant,
has.
we're over time.
Thank you.
Thank you. Thank you.
Have a good day.
Next caller.
Sarah, there are no other callers to provide public comment at this time.
Okay, thank you. Then I will go ahead and close public comment, and that concludes our agenda for the day. So thank you, members. I will see you all back at 8 a.m. tomorrow morning. This meeting is adjourned.